Hi, warriors. This is Jalen, my legal warrior, and today we have Julie Wolf, who's a juvenile dependency attorney here in San Diego. Hi, Julie.
Hi, thanks for having me. So I've been in practice about 10 years now. I do mostly juvenile dependency and family law cases. I also have an LLM in dispute resolution, and I do some mediation and problem solving. And lastly, I have a child welfare legal specialist certificate. So that's a California and a federal certificate.
So what is that child and welfare certification?
Well, it's a both state, California state and national certificate. It's from the National Association of Counsel for Children, along with the ABA and the California Bar Association. It basically means that I've passed a specialist test, a written test, a background check, and that I've had sufficient years in practice to be able to determine my knowledge of the subject matter.
Awesome. So basically, you're an expert. Again, thank you for joining us today. I'm going to ask you a few questions. First, I want to start off with, can you do a brief overview of the juvenile dependency process and then roll into how the system has been affected?
Sure, no problem. So juvenile dependency is a complex process. It's like nothing else that you learn in law school. So basically, juvenile dependency is when the county gets involved because they feel that kids are at risk of abuse or neglect, or they've actually been abused and neglected. So if that occurs, then the county will file a petition to detain the child. They can either detain the child in the home or, in most cases, outside the home with, say, a relative, a foster family, or sometimes, unfortunately, a group home. Like here in San Diego, we have the Polinsky Center. So there are certain stages to the juvenile dependency process. If the children are detained, then the parents will likely get services to try to get them to reunify. So, for example, if the kids were removed because the parents had a very bad drinking problem, and when they drank, they hit each other, threw things, things like that, then it would be likely that the parents would be given reunification services that the county would pay for. And the reunification services would be geared toward the issue that brought them to dependency. So in our hypothetical, they would have some substance abuse counseling, they would have testing, they would also have domestic violence counseling for themselves, and also how domestic violence affects children. And if they did go through those different classes and processes, and they were able to understand and make changes in their life based on what they were learning, then, and visit their children regularly and show that they are getting it, that they do understand now why their kids were at risk, and they're committed to not putting their kids at risk again, then ideally they're going to reunify and get their children back. The process usually can take anywhere from 6 months to 18 months if they are going to get to reunify with their children. So the other thing that you asked was, what's going on now? And a lot of things have changed. It's kind of been day-to-day in dependency. Courts were closed, like you could not get in front of the court. But shortly after, dependency did open up and have detention hearings, because when someone takes your child away, you have a right to be heard. So now in dependency court, the detention hearings are happening. They're happening via Microsoft Teams, where everyone appears virtually. So they are still having those kind of hearings. For other kinds of hearings, they are on hold, essentially. If all the parties get together and have a stipulation, then they can submit the stipulation to the court, and the court will process and go forward. So say if it had been 12 months and all the parties, the minor's attorney, the mom's attorney, dad's attorney, county counsel, everyone is on board with closing the case, then they let the judge know we're all on board with closing the case, and the judge can do an order to close the case. So those hearings can still go forward. However, if there is going to be a contested proceeding at a level later than the detention hearing, then those are still put off. The main thing that seems to have happened in dependency is parents, one, if they're supposed to do these services. So normally they would go to substance abuse treatment, say 3 times a week. And now it's more difficult for a lot of them to do that. Also, some of the classes, say parenting, things like that, are no longer taking place like they used to. So that makes things harder for parents they want to start the reunification plan as soon as possible so they can graduate and eventually have their kids come home. Another problem has been even visiting their kids, because with everything that's going on, some take, a bus to visit their child at a certain center, and maybe the center's closed or McDonald's is closed where they normally meet. And then also maybe the foster parent has some special needs children, so they're extremely uncomfortable with having one of the children in their care visit a bunch of other people. So that's been definitely another problem. I know that the courts have tried to facilitate visits via Zoom and via telephone, but as you can probably imagine, if you're 6 years old, you don't really want to spend 2 hours on the phone with your parents having visitation when you used to go to McDonald's and be able to play with them and things like that.
So are they actually not able to have physical visitation due to COVID-19?
So it depends on the family. Some of the families are still having, if they're able to, have in-person visits, but especially when the visits have to be supervised, those are more difficult. Mm-hmm. So when possible, they've tried to have those visits be via a virtual session, whether it be Zoom or FaceTime, something like that.
Right. Yeah, I actually wondered about that, because I know that CDC has allowed, and County of San Diego has allowed for child health care facilities to have up to 10 individuals. And so I figured that the supervised visitation monitors and facilities would also fall in line. But it sounds like from what you're telling me that that's not actually, the case. And now that I'm thinking about this a little bit more out loud, it makes sense that wouldn't necessarily be the case, because I think that the CDC guidelines has to be the same 10 individuals every single time and every single day. And that's it. They can't include or even mix the different groups. So if a facility had more than one room, then those 10 kids can only be in those certain rooms and they can't mingle. So I guess for a supervised visitation monitor, right, how would you do that? And I guess the answer is that you really couldn't. So
right, it's definitely hard. And some of them will, like I believe Hannah's house is doing some virtual appointments, at least that they can supervise that way. But normally a lot of these visitation centers, they might have 30 kids per day, because Joey comes on Monday, Wednesday, Friday, and Emily comes on Tuesday, Thursday, Saturday, and they're just all different kids depending on the schedules, the visitation schedules, and the kids are just going in and out.
Yeah, I guess we just have to get creative with it. Before we dive into the next one, is you said that as soon as a parent loses their kid, they're entitled to a detention hearing. Like, how soon can they get that detention hearing?
When someone takes the child, removes the child from their home, in order to do that, they do have to have a protective warrant signed by a judge. And the judges are still on call to sign protective warrants any day of the week, pretty much any time of day. But once their children are removed, they're supposed to be getting a detention hearing within 48 work hours. So say if it were Friday, they would still have maybe till Tuesday.
got it. All right, so it's actually quite quick. Okay. All right, but so there isn't really a delay just because of COVID-19. They'll still get it within
The,
the business
it,
hours.
there may have been at first.
And has COVID-19 impacted juvenile dependency proceedings in any other way?
The minors councils that represent the minors, they still have a duty to visit their children. So I know that they're doing what they can. Some of them are at like San Pasquale Academy, all over. And so they are still making efforts to make sure that the children that they represent know that they're still representing them, and just making sure that they're okay.
Well, what can parents do right now if they did lose their children to the state?
County would be the one to remove the kids. They would be assigned a social worker. So they want to make sure to keep following up with that social worker. They want to make sure that they have a case plan and that they know what their services are. So if they can't get into the parenting class that they want, the in-person parenting class, then I suggest, at least right now, trying to take a parenting class online. Reading a book, doing other things that are going to help you address the issues that brought the case to dependency. Your social worker, keeping in touch with that social worker at least once a week, calling, phone, email. If the social worker doesn't respond, maybe give them a few days and try again. If you still don't get a response, you can always call the supervisor just to make sure that you're checking in, that you're doing what the social worker is asking you to do, that you are available to visit at every opportunity. So whether that be Skype at 8 p.m. and 8 p.m. is, I don't know, for whatever reason late for you, then try to make yourself available at 8 p.m. because unfortunately there aren't a lot of options sometimes right now. So although Skype or Zoom meetings and visits aren't ideal, it's better to have something than nothing. So if you're offered visitation, whether it be Skype or Zoom or anything else, really just try to participate, try to make the best of it for the time. Also, you can keep in touch with your attorney. Again, you probably have your attorney's phone number and email. So keep in touch with them and make sure that you are doing what you can to either be in your services or get in your services as soon as you can.
All right. And then how are parents reunifying with their children during this time? I know you touched on it, earlier, actually gave a pretty extensive plan for parents to go ahead and go through virtual parenting classes. And then for the substance abuse, if I'm not mistaken, there are facilities or programs are also providing that virtually. And that would satisfy
So, well, the substance abuse testing isn't available virtually. You have to go there, but a lot of the places are still open and are still testing. As far as AA meetings, there also are still some AA meetings that are still occurring. The next thing that you might want to consider is doing an online class. Your online class might not be recognized, but at least you're doing something as opposed to just waiting it out, because we don't know how long this is going to last.
So if a parent is required to do AA classes, for example, and the facility that they used to go to do not offer a virtual option, then they need to find some other option to try and I guess hope that those requirements are going to be fulfilled by their virtual attendance, because like you said, it's better to do something rather than nothing. But there is a possibility that the court might say, actually, that's not even enough. We appreciate your efforts and you're going to have to continue doing the in-person sessions until like the next hearing.
Interestingly, the county has a duty to provide what's called reasonable services to the parents. So I'm sure when the courts reopen, there are going to be a lot of arguments that the county did not provide reasonable services. Obviously, the county couldn't because of the national pandemic. But then if the county is trying to terminate parental rights or something like that, then they're supposed to provide reasonable services. And I think the parents would have a good argument that if they can't get in services, then they didn't have reasonable services. But I just would recommend, if you can get in some services, get in some services. Although it's not ideal to have online services, it's much better to have in-person services. If you can't have in-person services, go for the online services.
All right.
So,
And a lot of these individuals, just from my understanding, that are in that process, they're unfortunately in a situation where they don't necessarily have the economic means to even do like
right.
a one-on-one with a professional that would typically run the programs or the classes. So that's another hurdle, I suppose, for that.
Well, the county does have a duty to provide them with services. So a lot of them, like for individual therapy, a lot of therapists are doing telehealth. So they can still get therapy at no cost to them or extremely low cost to them. But the other issue, like you were saying, is access to justice, because the services would get them their children back. So it kind of is a justice issue. But if you don't have a phone where you can do telehealth, or you don't have your computer and you can't do telehealth, that certainly causes another burden during this time to be able to reunify. And are services reasonable if you don't have a phone and you don't have an option? Then I don't know if, that I don't think there's been that I know of, there hasn't been a court case saying that the agency has to give each parent a phone. That hasn't occurred. But there's supposed to be reasonable services, and if you know that this parent doesn't even have a phone, they still need to be able to access the services.
Yeah. One last question about your reunification proceedings, like by the time they actually get to their final hearing and they're able to, in fact, be reunified with their child. I know you said it was like 6 to 18 months. Is 6 the shortest and 18's the longest?
Well, after the detention hearing, there comes a jurisdiction hearing. The jurisdiction hearing is basically, are the allegations that the child was unsafe true in some form of another? So if the allegation was failure to protect, and the child was in a domestic violence, very close to a domestic violence dispute, and had a bunch of things thrown and was in the next room, whether it was Tuesday or Thursday, usually in my experience, it could still be found true. But once it's found true, then the next hearing is the dispositional hearing, which is basically, what are we going to do about it? How are we going to dispose of that? Sometimes at that hearing, the children will be placed back in the home of the parents, even if they were removed at the detention hearing. And perhaps there can be services put in place to make sure that the children are safe in that home. So sometimes that will occur at the disposition hearing. And then sometimes things are put out for so long that at the disposition hearing, say that the disposition hearing is supposed to be held within 30 days if the child's removed, 60 days if the child is still in the home. But say for whatever reason, the detention hearing or the disposition hearing is put off for, say, 2 months, by the time we get to this dispositional hearing, the parent maybe completed a lot of services. They now have, say, their grandparents living in the home supervising. They've just done so much to take care of all the issues that brought the case originally to dependency. The judge does have the power at the dispositional phase to concoct some sort of plan, or that the case would close.
Gotcha.
And then also the parents can at any time file a motion under the Welfare and Institutions Code, section 388, to say that there's been a change of circumstances and that they would like the case to close.
Gotcha.
So they can theoretically file that at any time.
Okay, that's good to know. I'm sure that's actually probably a great tip for our viewership
Yeah.
to know that.
Yeah.
Again, thanks for joining us today. I learned a lot. Tell us a little bit as to how our viewership can get a hold of you.
Great. Thank you so much. I really appreciate you having me. I love your webcasts and all your postings. Big fan. So to get a hold of me, my phone number is 619-77-SOLVE. So 619-77-SOLVE. I can be reached at www.jwolflaw.com. Wolf is WOLFF. Also, you can subscribe to my YouTube channel, which is Julie, middle initial O, last name Wolf, WOLFF. So thank you.
Perfect. Well, thank you so much, Julie, and we hope that our warriors do stay safe. Be well.